Welcome back to the Emily Show. It's the end of November and I absolutely cannot believe it. But even though it's Thanksgiving week here in the US, courts do not stop. Well, on Thursday they do. Thursday courts are closed. But other than that, they are trying to round out the year and get cases off of their table, get published opinions out. I don't know if we'll see anything in the Karen Reed case, but she was back in court on Tuesday, November 26th, and we will see if the court agrees to continue her trial date. And we have some updates in a few other cases today. We need to talk about Diddy's bail hearing, and there are a ton of filings in the Idaho prosecution of Bryan Kohberger. I'm going to do a summary of those. We are still waiting for the prosecution to respond, and there are some challenges going through it, but the judge has been incredibly active. So when we get to the end of this motion briefing, we will see all of these hearings on calendar because that scheduling order has already been done by the judge. He is incredibly organized, which I appreciate because we just know what to expect. So with all of that, we should just get into it. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. First, a huge thank you to everyone and your incredible feedback on the Law Nerd Shop 2.0. If you did not know about our new launch in the Law Nerd Shop, be sure to check it out. And if you had the Law Nerd app, you would have known that we had a whole new drop. There are a few items still available, and you still have a little bit of time left for holiday shipping. So if there is a Law Nerd in your life, or you're just ready to treat yourself, go check out our first drop of the new Law Nerd Shop 2.0. And I am so glad you are loving it. I am too. You know what I wasn't loving though? Reading like 15 motions to suppress in the Idaho prosecution of Bryan Kohberger. And while they need to be made, it was an extensive amount of motions, but we should probably do a real quick update in the Girardi prosecution first, shall we? Remember, Tom Girardi, disgraced, disbarred, convicted former lawyer, estranged husband because the divorce is still not final yet, of Real Housewife of Beverly Hills, Erica Jane. He went to trial in federal court in Los Angeles and was convicted. The defense still has multiple motions pending for new trial or for judgment of acquittal. He was supposed to be sentenced in early December, and that sentencing date has now gotten pushed back to December 20th, and the deadlines for the sentencing memos have been pushed back. The thing I am waiting for the most is to see what the government's sentencing recommendation is. That's really the one thing I am waiting to see. What's funny about that is that the criminal prosecution in Illinois had pushed their date back to December 19th because they wanted to see what Girardi would be sentenced to decide what they were going to do with their prosecution. Well, Girardi's new sentencing date is December 20th, so I imagine we will see the date for that hearing in Illinois getting bumped back as well, probably into early 2025. And if you are looking for other pop culture updates, the Shannon Bedore facelift lawsuit and the rest of it, I have been covering that over on Quick Bits. If you're listening on the audio feed, it's right here. If you're on the YouTubes, it's on the Emily D. Baker Quick Bits channel. And again, if you're in the app, those all go into the app so you can see all the episodes across all the channels. But I have been trying to keep you in the loop faster over on Quick Bits and on that Monday episode, which starting in 2025 is going to be the only pre-recorded episode, as I am pushing into more live streaming in the new year, because even recording a day or two in advance sometimes feels like it's slow for the stuff we're covering. I'm like, no, we need to go now. Too much is happening in court. So Tuesday, Wednesday, Thursday, I will be live streaming at the Emily D. Baker on YouTube starting in 2025, and I can't wait. But that Monday episode will keep you in the loop with everything else. Speaking of in the loop, let's summarize everything that's going on in Idaho because it has been quite a lot of filings. As I said, Judge Hippler has done a really good job of putting some structure around this case. I think he has been tremendous for this case. He seems to want this case to move along, but we saw what he said that very first hearing when he came in, and I have never really seen a judge quite do this. I'm sure they think it all the time, but I have not seen a judge look at the attorneys and say, I would love to tell you all I'm happy to be here, but I don't want to start with an untruth. I'm like, oh my God, Your Honor. It's something, but it's very clear to me that he wants this case to proceed orderly, smoothly, and swiftly. Not more swiftly than necessary, but swiftly. So the next date for discovery motions is January 23rd. The judge has set aside possibly 2 days for those hearings, and those are going to be hearings on all of these motions that we're talking about, the motions to suppress and any 12B motions. So really it's only motions to suppress because the defense deadline has passed. So all of these motions are what they are dealing with. So the prosecution will have an opportunity to respond, and then this hearing will happen later on in January. Well, these hearings, it's the way you saw the penalty hearings go, where the court handled in succession all of the different motions. And that's the same with these motions. Some of the motions are filed by different members of the defense team. So we'll have different members of the defense team arguing different motions. With the defense motion, there are a ton of motions, but there are 2 that are really the basis or are part of the basis for all the rest of the motions. And that's a Frank's motion and a motion to suppress the IgG data. We're going to talk about both of those first. The other motions to suppress all include the motion for the Franks hearing and then the motion regarding the IgG. Here's what's frustrating about it. Both the motion for Franks hearing and the motion to suppress the IgG data are sealed essentially. So there's a notice of motion, and both of them say, the parties stipulate to the sealing of the proffer and exhibits. The stipulation is filed contemporaneously. The under seal proffer and exhibits are being provided to opposing counsel and court staff via email. So the motion for Frank's hearing and the motion to suppress IgG are both sealed. Emily, you might be asking at this point, what is a Frank's hearing? The Frank's hearing is the defense asking for a hearing stating that something was misrepresented in the search warrant. Either exculpatory data was left out of the search warrant or information in the search warrant was misrepresented or untrue or lied about. And so they are trying to suppress the search warrants based on that hearing. And then they are also trying to suppress the IgG information. And then in a lot of the other suppression motions, they are arguing that the IgG data is essentially the foundation for those search warrant affidavits. So if that piece is tainted or if that piece is suppressed, then when you pull that piece out, everything else crumbles. So they are attacking the foundations, or what they say are the foundations of the other search warrants, to take all of them out. And if the search warrant is bad, then anything that is discovered subsequent to the search warrant is or can be fruit of the poisonous tree. Now, there are some exceptions with regard to whether it would inevitably be discovered and things like that. So there is a larger conversation. Today, I'm doing an overview of what the defense is asking for, and it's hard to evaluate search warrants when you can't see the search warrant, and we don't have them. Everything is sealed. So we are basing these off of the defense motion without having the prosecution opposition to fill in the gaps. And even then, we're not going to have all the gaps filled in because it's sealed. So I'll be really interested to hear if that Frank's hearing is part of the public hearings or if they are going to seal the court for the Frank's hearing and maybe for the motion to suppress the genetic information. But we do see the defense make some arguments about it in the motions to suppress we're going to be going over. But first, with regard to the Frank's motion, the court filed an order sua sponte on their own motion on November 22nd because the court is not happy. So Judge Hippler files this on his own motion, November 22nd, saying, before the court is defendant's motion for a Frank's hearing from November 14th and the memorandum in support of the motion for Frank's hearing, November 18th. Look, the motions were due November 14th. The defense hand-delivered it, but also emailed it. So I don't really see as a problem. This is the problem. Accompanying the motion are 38 exhibits comprising over 2,000 pages. Oh boy. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits instead referring simply to the exhibit number without identifying the precise pages at issue. Footnote 1. By way of example, defendant cites generally to Exhibit D9 for the proposition that law enforcement's vehicle expert felt more comfortable setting the date range of 2011 to 2013 for the Elantra. The exhibit is over 100 pages of duplicative emails. Defendant does not identify which email supports this proposition. The court will not do counsel's job and scour the exhibit to decide what portions defendant must be suggesting supports his assertion. Oh boy. So the court said it in that footnote. The court will not do counsel's job. When you are citing the court to an exhibit, especially a lengthy one, saying an expert in this example said this, the cite to it should be exhibit this, page that. You should cite more specifically if you are pointing out a particular point. The court goes on in the way that Judge Hippler does, saying, thus, the court is left with the unenviable task of sifting through pages and pages of largely irrelevant documents to ascertain which portion defendant may be referring to. And the court is now quoting case law. The court is not required to search the record looking for evidence. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony for the facts asserted. In addition, defendant must resubmit his supporting exhibits to exclude portions that are not relevant to the motion because the state is under a deadline to respond. The court will allow the defendant until Tuesday, November 26th to submit revised filings. So in that order, the court did a few things. One, the judge said, no, people, I am not giving you an extension, but I am telling the defense that they have until Tuesday, November 26th to file the revision. Happy Thanksgiving, everybody. You're going to have a great time reading through the revised motion. However, the revision will also help the prosecution, who generally knows what the defense is saying and is probably more familiar with the exhibits than the court is. But the prosecution also took issue with the Franks motion and the IGG motion and made their own motion objecting to them. On November 20th, the prosecution made a motion to strike the defendant's motions. Why? You can probably guess. Because they were over the page limits. Emily, do lawyers really care this much about the page limits? Yes. Yes, they do, especially when they have this many motions to respond to. So the prosecution brought their motion saying that the local rule says memoranda in support of non-dispositive motions, quote, must not exceed 15 pages. The prosecution says defendant violated this rule when he filed a 37-page memorandum to support his motion to suppress the genetic information and a 33-page memorandum in support of his motion for a Franks hearing without seeking leave of the court. We learned a lot about this from Carrie Morrissey in New Mexico. The local rules have page limits for everything. However, these are important motions. They do decide issues critical to the case, and the court responded very quickly. The next day, November 21st, Judge Hippler said, denied. In a few more words than that, quote, before the court is the state's motion to strike defendant's memorandum in support of motion to suppress regarding the genetic information and memorandum in support of a Franks hearing. The state aptly points out that both memoranda violate Rule 8.1 of the 4th Judicial District local rules, setting a 15-page limit on memorandum in support of non-dispositive motions. Defendant's memoranda at issue are 37 and 33 pages respectively. Moreover, defendant did not seek leave of the court to file overlength memoranda, which is contemplated by local rule 8.3. Given the breadth and significance of the two motions at issue, the court declines to strike the memoranda. Had defendant moved for leave to file overlength briefs, it would have been granted. The court will, however, allow the state an equal number of pages in filing its responses to the two motions. In future, counsel shall abide by the page limits set by local rules or seek leave of the court in advance of filing an overlength brief. We learned from watching Judge Hippler in court that Judge Hippler is going to be fairly strict when it comes to the rules. Look, society has rules. Court is one of those places where some judges, trial level courts, might be a little more formal, might be a little less formal, depending on the judge. Judge was a little more colloquial with everybody. And you could see Judge being like, it's fine. I want to read it. I want to hear what you have to say. We'll sort it out. Judge Hippler has said, I would have granted the motion, but you need to make the motion. So what we have seen is a strict adherence to the rules. And I think all the attorneys in this case are now on the same page with that, because this judge has made it abundantly clear. I think we're all well aware that what this judge is going to do is follow the rules first. And we saw that in his questioning. He very much has the demeanor of an appellate court judge. Very prepared, very engaged, but also a very tight ship is being run. But those are not the only filings that have happened. And yes, we're going to get to the motions to suppress, but the government also filed a motion seeking to amend the petition for appointment of special counsel, and then immediately seeking a decision on that briefing, saying it was a routine matter. And the court also ruled on that. And then the defense objected. Also on November 21st, the court issued this amended order appointing special assistant attorneys general. This matter having come before the court upon petition of the Latah County prosecuting attorney and good cause appearing, it is hereby ordered that pursuant to IC 31-2603B and 67-14017, that Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as Special Assistant Attorneys General to assist in the prosecution of this case. So essentially this is a staffing issue, but because Latah County is the prosecuting agency, it seems that the court has to allow for the state's Attorney General to come in as assistants to the prosecutors in this case. Well, the defense said not so fast. Also, on November 21st, the defense filed this objection, saying that the grounds for this objection are that the state has not articulated good cause for the appointment. Idaho Code does not authorize multiple, quote, attorneys general, and Mr. Kohberger will be denied the right to a fair trial if the state is given the broad authority to appoint multiple special assistant attorney general without any specification of who and how many. Footnote 1. Defense counsel reached out via email to the state to seek an understanding of the state's intentions. No response was provided. And then they cite the statute saying the prosecuting attorney may petition the district judge of his county for the appointment of a special assistant attorney general to assist in the prosecution of any criminal case pending in the county, and if good cause appears to the district judge to whom such petition is addressed, that good cause appears for granting such petition, the district judge may, with the approval of the attorney general, appoint an assistant attorney general to assist in such prosecution. Look, these are staffing issues, but the defense goes on to say the plain language of the statute allows, upon a finding of good cause, for a assistant attorney general to assist in the prosecution. They go on to say that the authority sought in the proposed court order is that Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as Special Assistant Attorneys General to assist in the prosecution of the case. This language, when coupled with the explanation in the petition and the letter that accompanied the petition, is to grant Mr. Nye or his designee carte blanche authority to choose, quote, assigned Deputy Attorneys General as may be appropriate. The authority sought in the petition and draft order is without any rationale for good cause and is beyond the scope of the authority set forth in the statute for a attorney. They go on to say this is different than what the state did earlier in this case when the state first sought the appointment of the Idaho Attorney General's office in April 2023. The petition set forth two specific names. The time for Mr. Kohberger to object is now because Idaho case law indicates that once a special assistant attorney is appointed, there is no collateral attack available absent a showing of an unfair trial. So they're saying we have to preserve the objection. They say it is important that Mr. Kohberger have knowledge of what prosecutors are acting on behalf of the state to preserve all issues associated with a fair trial. Footnote 2, the state currently has the assistant of the U.S. Attorney's Office for the District of Idaho, United States Attorney Joshua Hort, and Assistant United States Attorney Tracy Whalen have conducted grand jury proceedings, the extent of which is only known through over 70 subpoena returns and 2 SDTs, subpoenas ducis tecum. So the defense is saying that they are aware that attorneys from the United States Attorney General's office, the federal Attorney General's office is helping, but now they are also looking to tap in attorneys from the state's Attorney's General office, but there are already state's attorney generals working on the case, and we've seen that attorney arguing in court. So we now have prosecutors from potentially 3 different agencies working on this court, and the defense is like, who is working on this case anyway? The defense goes on to ask for a hearing on the matter, and they say it is not a routine matter to give an entire legal division of the Idaho Attorney General's office authority over who to appoint as prosecutors in the case. Though that's generally how that works in a case, is that the prosecutor's office choose who prosecutes a case. So we will see if this matter gets addressed when the other hearings get addressed in January. But with the amount of discovery and litigation in this case, I'm not surprised that the prosecution's like, hey, we need to extend the order so that there is flexibility within who is appointed from the Idaho State's Attorney's Office. That might just be due to staffing, that they need to change who's assigned to the case or what have you. That's not uncommon that prosecutors get changed in and out of cases depending on what's going on with the case, their own scheduling, their own cases, etc. Now let's talk about the motions to suppress. The defense filed motions to suppress for the defendant's Amazon account info, the search warrant to search his apartment, his Apple info, the arrest warrant, a first warrant for his AT&T data, for cell phone data, for his Google account data, for a pen, trap, and trace device, for the search of his person in Idaho and in Pennsylvania, for the search of the white Hyundai, and for statements made subsequent to arrest. All of those are going to be heard in January. All of them also say that the warrants are bad based on the Franks material and based on the fact that the defense is arguing that they are all supported by the IgG data and they are trying to have that thrown out. Again, the IgG data is that genetic information where they took a DNA profile from the knife sheath found next to one of the victims, and then they took trash from Bryan Kohberger's parents' house and determined that the DNA from the trash was likely the father or at least close genetic relative to the male DNA on the knife sheath. What's not clear from anything that has been seen in public is how they got from a DNA profile on the knife sheath of supposedly unknown male to searching or taking trash from Bryan Kohberger's parents' house. How did they make that connection that Kohberger was a suspect and get to Pennsylvania to follow that information in the first place? That bridge is still very unclear. And a lot of the hearings on this matter have been sealed. So I don't know if we will know how they made that connection, but maybe we will. And there is more information about this case in these motions that was not known before, including the fact that the defendant made statements at the time of arrest and then continued making statements when he got back to the police department. One of the motions to suppress is saying that he was not initially Mirandized until he got back to the police department. They're also saying that there was no body cam footage of the search warrant executed at the parents' house and then the arrest warrant executed at the same time to arrest Bryan Kohberger at his parents' house. And the defense is saying that the conversation with the defendant prior to Miranda is being categorized as quote unquote small talk. So we don't know if the defendant made spontaneous statements like when they were arresting him and he said something, or if they were actually interrogating him. Because remember, the Miranda issue goes to an in custody or custodial interrogation. So was he being interrogated, or were they saying, hey, I know it's uncomfortable to be sat in a car with your hands zip tied behind your back, but we'll be there in about 10 minutes. Do you need to go to the bathroom? It's what was said. And the defense is saying that those pre-Miranda statements were not on body cam. So there's going to be a lot more information needed for the court. We'll see what factual information is in the response from the state. We also saw in a lot of these motions some growing tension in law with regard to what information is too much information to be gotten from third parties and how are the courts resolving this. Generally, a person doesn't have a privacy interest in what a third party has. So you know that if you give your personal information to like the grocery store as part of your rewards program, that's not really private information. You don't have a reasonable expectation of privacy in it. And so law enforcement could go to that third party grocery store and say, give us, the rewards information for this individual. But where are the boundaries of that in a digital age where so much of our life is digital, either on our devices, online, in our cloud accounts? And where is the boundary between what a third-party provider can turn over or not, and how particular or specific the warrants need to be? And there are a lot of arguments in these motions about how particular or specific the warrant needs to be. And some of these warrants are fairly broad and vague, but warrants need particularity. The one that caught my attention specifically was the motion to suppress with regard to Apple. So we're going to talk about that one in a little more detail. When we're looking at the motion to suppress for the Apple account and federal grand jury subpoena, which means not only was a search warrant done, but the grand jury also subpoenaed some information, they are looking to suppress all data found by law enforcement from its search of Apple accounts and an iCloud account. They say that Kohberger has a privacy interest in the account, that the warrant was based on the IgG data and the Franks information. So all of that is a reason why the evidence gotten from this warrant should be suppressed. And then they also say that the warrant fails to provide specific particularization of what is to be searched. They go on to lay out that on December 21st, 2022, the FBI issued, I know, we can't not.
The FBI!
I know, one more time.
The FBI!
Issued a preservation letter to Apple on December 30th. Pennsylvania law enforcement, along with officers from Idaho, and
The FBI!
raided Kohberger's parents' home in Pennsylvania and arrested him. An iPad was located at his parents' home, but it was not seized because it was in a common area, which means they couldn't determine whose iPad it was. During a subsequent search of Kohberger's vehicle, a receipt was located for an Apple iPad. Based on incomplete records available to the defense, the FBI served a grand jury subpoena on Apple on January 12th, and Apple produced responsive data on January 27th, and then they list the Apple accounts. They then go on to say that a search warrant was served on August 1st, 2023 to Apple to get the download information, and then that was not particular enough, and they're arguing a bit that there wasn't sufficient probable cause. But the thing that caught my attention the most is that the officers were requesting a time frame from October 7th, 2016 to December 30th, 2022 for any and all Apple accounts linked to the iCloud account. That is a very broad time frame for this crime that happened during a discrete period of time. It was, if not just one night where the crime was carried out, I can't imagine that they would find something from 2016 that is going to be informative to what was happening in November of 2022. And if there is, they would have needed to have that information in the search warrant affidavit. That is an incredibly broad time frame. So on this, I do agree with the defense that that is a long period of time to go through and look for evidence of a crime in November. But I don't know what planning you're going to see in 2016. And you can't just go on a fishing expedition. You have to have some information that leads you to believe that there might be information and evidence back that far. And I don't even know what that would be in this case, but because we don't have the search warrants, it's really hard to tell. And then the request is also fairly broad. The contents of all files and other records stored on iCloud, including all iOS device backups. That's everything. You can't just rifle through everything somebody possesses. You can say, we are looking for location data in this time frame. We know this car was in these locations. We want to see if this phone was in this location. But all files and records stored on iCloud is incredibly broad. It goes on to say all activity, connection, and transactional logs for the account. But back to 2016, how are you tying it back that far? The defense goes on to say that in this matter, Corporal Payne specified in his request that the purpose for gathering the information from Apple was a belief that Apple accounts would provide information concerning Kohberger's plans, thought process, research, locations, photos, and other pertinent information stored on his Apple account, including his iCloud account. But how do you get back to 2016? I still am unclear. They go on to say that pursuant to the case law they cited earlier, to the extent that information gathered included information from an Apple account created in 2016 and an iPad purchased from 2018, such information included device backups, private emails, documents, photos, and videos that predated the applicable time frame that Kohberger was in the Moscow-Pullman area. They say that Kohberger has a privacy right protected by both the Fourth Amendment and Article 1, Section 7, and this was in essence a cell phone search. They were searching just his entire cell phone. They're like, yeah, we just want everything. So when it comes to the Apple account, I am very interested to see what the court will do with how broad that time frame is and see what they think will tie it back. You can't just get to everything forever. You have to note, and this is kind of the push-pull with digital data, is that there is so much data. But if you were going to someone's home to search for evidence of a crime, you couldn't necessarily just start opening physical photo albums and start flipping through them to see if they had pictures with them and another person without that being noted in the search warrant. You couldn't just go start searching into their bank records and documents if that's not noted in the search warrant. So the search warrants have to be particular, and that is something that is noted in all of these digital search warrants and an area of law that is continuing to try to accommodate laws that were written for not going into somebody's house and just rifling through all of their shit. But what is the digital equivalent of going into somebody's property and rifling through all of their shit? Isn't it being like, well, there might be something in the photos, so can we look through it? And how particular does it need to be? So the defense is bringing a lot of the arguments in these motions to preserve them for appeal because the courts just haven't addressed all of these areas yet and have addressed it pretty sparsely. And that's the same when they're looking at the Amazon and the Google. With Amazon, they're looking for an entire shopping history. However, in the Amazon warrant, from what we know from the motion to suppress, is that there is a vague reference in the warrant to an FBI special agent locating an account for Kohberger,
The FBI!
and that Amazon provided order history records regarding a customer email, and then they put in the customer email. It's a Gmail account that's also subject to the Gmail searches, and how the agent located this was not explained. So they're saying, how can you even get to probable cause here? We can't see the warrant, so I don't know the full context there. It also says investigators know that Amazon holds records for identifying devices the customers use to access their account, all linked accounts, other items customers have searched, clicked on, placed in cart, viewed, saved, what have you. And then it says that the time frame for this was March 20th, 2022 through March 30th, 2022, and November 1st, 2022 through December 6th, 2022. With that, you have a much narrower time frame, and they're looking for purchase history. They're not, it seems, asking, or law enforcement in the warrant wasn't asking for the purchase history, what device was used to make the purchase, what the IMEI number of the device was, what IP address that device was connecting to, if there was other data connected to the Amazon account. This one seems much more particularized in that the date range is fairly narrow, and what they're asking for is a purchase history connected to a particular email account. I think if the other things aren't an issue on this one, it's going to be fine. It's much more narrow. It's not like, hey, let us see what we find. It is very specific. And when they're asking for purchase history, I would imagine they're looking specifically for the type of knife, of the knife sheath they found with the DNA on it. However, if the DNA is tossed out, then there might be those foundational issues, but that is for another day. So in kind of summary, it's going to be very long days in court arguing all of these motions, because while they have some similar foundations with that DNA data and with the Franks data, they do also have different and more discrete areas to argue. The Apple one being more broad, the Amazon account info and purchase history is a bit more narrow. And then you're looking at all of the Google information from multiple email accounts. but the defense is saying that those email accounts aren't tied together. How do you know this account connects to Bryan Kohberger? And is that really probable cause? And is that going to be sufficient to sustain the warrant? And then we get into questions about what happened when he was arrested at his parents' house and whether those statements stay in or whether those statements will get suppressed. And then the same with anything from the white Hyundai, the movement of the phone, the data from AT&T, and more. I will go over these more when we also have the government's opposition to these motions to see if we can really flesh through a little bit more information, because with, again, Emily, you're saying all the warrants are sealed, so it's really hard to evaluate the warrants. Well, it is. It's hard to know because we are getting little bits of information. The court will have all that information, so will the parties. So they are at some point speaking vaguely about the facts and very specifically about the law. But the law is still trying to tackle what our digital landscape looks like, what a search of your digital home essentially looks like. And we're going to see a lot of those arguments in court, and I'm interested to see it. So speaking of digital and phones and communications, it's time for the segment of just about everything I do. What did Diddy do now? But before we get into Diddy, I'm going to take a moment to thank our sponsor, HoneyLove, because it's something that makes me smile. And I'm smiling not only because I love the bras, shapewear, and sleepwear from HoneyLove, but also because they have an incredible discount for you. So if you've been like, ooh, maybe it's time to treat myself, now is the time. Say goodbye to uncomfortable underwire and bulky fabrics that trap heat. HoneyLove's bras feature supportive bonding that eliminates the need for underwire without sacrificing lift. Plus, they're made with fabric that's so soft you won't want to take it off. And their shapewear uses targeted compression technology, so you no longer have to feel like you're suffocating while wearing effective shapewear. You'll immediately see and feel the difference. No tugging things down, no things rolling down when you don't want them to. So if you're ready for all of your holiday looks to look the best and you feel your best, HoneyLove is for you. Plus, if you want something comfortable to slip on after you take everything off for the night, do not sleep on the sleepwear. It is what I wear every single night. Supportive whether you're out and about or whether it's time to snuggle up in bed. And save up to 60% off site-wide at honeylove.com/Lawnard. You heard me right. Save up to 60% off site-wide till December 4th only. Inventory is limited and the sale ends soon, and you don't want to miss their best deals of the year. And after you're purchased, make sure to tell them the Emily Show sent you. Elevate your comfort, elevate your style. Thanks to HoneyLove. All right, let's get back to talking about Diddy. I've started feeling like when we talk about the Diddy case, I feel like I'm giving like a Bravo recap. Last time on Diddy, we were getting ready for his lawyers to go to the bail bond hearing to explain themselves about the fact that legal was written on those legal pads, but weren't in the pictures that were turned over by the people. So that's where we left off. And I covered a bit of that on Quick Bits too, but let's talk about what happened at the hearing on Friday, November 22nd. And this is all coming from in-court reporting from Inner City Press. So when Judge Subramanian takes the courtroom, the first thing he says to counsel is, "Tell me about the legal pads." Of course he does. And Combs' lead attorney says, "The first time I saw them was Tuesday." Remember, that's when defense was in court and walked them up to the bench to show them to the judge. Combs' lawyer said, "As we sit here today, I'm not sure when legal was written on each of them." So that's a disclosure of, yeah, I don't really know what happened here, Your Honor. Defense said, "I'm trying to get to the bottom of it." Different members of the defense team was telling him to write legal on the pads. There's a photo of a pad without legal on it. So it's clear that on November 1st, the sweep, they did not all say legal. Judge Subramanian said, "The pad you handed up to me, did it say legal on it on November 1st? Counsel said, "I'm not sure." The judge said, "Moving forward, make sure representations are true," which is a fairly stern statement. You cannot misrepresent things to the court. And I saw a lot of questions about this. Does writing legal on the top of the legal pads change much about whether the contents of the legal pad are somehow attorney-client privilege? No. The big deal about it being written there is that the defense attorney represented to the court that that was written there the day that MDC was searched and that the government therefore really should have known that this was attorney-client privileged, and it showed that the U.S. attorneys were just flouting common sense and the rules, and that their breach of attorney-client privilege was just egregious, and anyone would have known. And they were using that as an argument to say, it's even worse than you thought, Your Honor. And the judge was looking at the photos that the U.S. attorneys provided, saying, well, on these photos, it doesn't say legal on that day. It does not make the contents of the legal pad legal attorney-client privilege work. It goes to what was represented and if the attorneys should have had more of a heads up. Because remember, the photos were taken by an investigator who works for the Bureau of Prisons and then sent to the U.S. Attorney's Office filter or taint team to see if there were things in there that were attorney-client privilege. But we know that the court also told the attorneys from the case team to destroy all of the photos that they had in their possession of all of the notepads until the court addressed it and had a chance to review it. He said the taint team could hold on to it, but the trial team could not. So it's not like the judge is all that thrilled with the U.S. attorneys either. Then they get back into court and they're asking the AUSAs about the laptop for Combs to review the discovery at MDC. The U.S. attorney said the idea is to preload the laptop with information he's allowed to have at MDC on the laptop. There is a protective order. It's not common that defendants that have attorneys get all of their discovery on a laptop, but they are trying to accommodate that given the volume of digital evidence in this case. The judge said on the bail application, I don't have to deal with the Butsani case, a different case. The defense is saying there are extensive conditions proposed, including 24/7 security. What about the Fox case? And the U.S. attorney said there's no RICO charge in that case. The judge said agreed. The judge said, but I want you to address the proposed conditions. And then the prosecutor said there has to be some level of trust that the defendant will follow them. Here, he will not. He cannot be trusted. Consider his conduct in custody. After the two judges' findings, his attorneys are unable, his flouting of the BOP's rules, consider the labeling of the pads after the fact, even family members. And the court cut the U.S. attorney off and said, what's your response if Mr. Combs says, even if they don't trust me, there would be 24/7 security? The judge is trying to reroute the U.S. attorney and say, no. Let's not talk about the attorneys. I want you to talk about the question I asked. The prosecutor said if he can't comply in a custodial setting, he will not comply if released. What type of security firm? They suggested a co-conspirator, one whose phone was taken only the day before. The second suggestion was a defense investigator in the case. So the U.S. attorney is telling the judge that the people suggested by the defense to be the 24/7 security for Sean Combs is an investigator that's working for him already on the case and one of his co-conspirators, which means it's probably somebody who worked security in one of his businesses since this is a RICO case. The U.S. attorney goes on to say that investigator has been out contacting witnesses. Essentially, they work for him. This would be the defendant buying his way out. The court then asked about whether or not the defendant's wealth factors in here, and the prosecution said we're not seeking his continued detention based on his wealth, but rather danger, risk of flight, and obstruction. And the judge said, is obstruction your main argument? And the U.S. attorney said dangerous to other, and the court said, so not risk of flight. And the prosecutor says, we still rely on that too. Judge Subramanian says, tell me about the obstruction. And the USA says he's continuing to violate the rules. And the judge said, is running a PR campaign obstruction. The AUSA said that's not what we have here. Rather, it's his concerted effort to impact the integrity of these proceedings. He says, I want to reach the jurors. I need only one. So we had seen things redacted in almost an ad libs type way in the defense motions and the prosecution motions. And I think this is one of the things that was redacted. He said, I want to reach the jurors. I need only one. The judge said he's not permitted to engage in any conduct to impact the jury pool. And the prosecution said his intent, it's obstructive conduct. He's violated the so-called gag order. He's the one who asked for the order. The AOSA said the court entered the order on October 25th. He started his campaign on the 27th. He couldn't even comply for 2 days. And the judge said, what about the Jeffries, which is the Abercrombie case, where the government agreed to release on $10 million bond? And the AUSA said, we did a letter. And then the prosecution says, I think the better comparison is the two prior denials of bail here. And the court said, what about the claim the government spliced the video? And the AUSA said he apologized. That's the point. The judge said, why did you use the spliced video, not the original? And the AUSA said it was public. So the defense is alleging that the video from CNN of the incident at the Intercontinental Hotel was, the court is saying, spliced. And I want to know a lot more about that, but it doesn't say altered. So did CNN edit that video? Because the U.S. Attorney's Office had said they did not have it until CNN got it. But do they have it now? And what are we talking about with the spliced video? The prosecutor's continuing on, and it looks like at this point they were talking over each other a little bit. The prosecutor continued on and said the cell phone footage was grand jury material, and we didn't want the defendant to be able to retaliate against grand jury witnesses. We did add blurring of the victim's face. In 2016, the defendant bribed hotel security $100,000 to make it go away. Does it matter if he threw a vase or the contents of a vase? He admitted to it and apologized for it. This took place in the middle of a freak-off. The U.S. attorney has evidence of a male commercial sex worker who was in the hotel room at the time. This is devastating evidence for trial. It shows why he cannot be released on bail. They go on to say he is violent and is committed to covering up his crimes. The evidence against him continues to mount. We've learned of punching and kicking employees and partners. And the judge asks for the defense attorney. Combs' lead attorney says, I'm going to have Ms. Shapiro lead us off. Ms. Shapiro says he was not dragging her back to the freak-off. The judge said there was dragging. The attorney said, I didn't mean to. The judge said there was kicking. Shapiro said he apologized. I mean, it doesn't mean he's not violent. The judge said, what about the 2018 text messages with victim 1 about violence? Defense attorney A said, we have gathered more information about victim 1 even yesterday. I don't want to quote it because it's under seal and should be. It was consensual. And this is what the defense has said over and over again. The judge said, I don't want to quote from them, but you know the ones I mean. Defense attorney says, we are proposing an independent security firm. There has been mutually regrettable physical conduct going both ways. There was violence by this other person and by Combs, allegedly. Shapiro then says, in the LaFontaine case from 2000, the defendant told someone to lie by phone from the MCC. In the Gotti case from 1996, the head of the Gambino crime family, the witness received a quote, kick in the ass. The government does not have that here. Shapiro goes on and say, we cited the Trump case. Defendants have greater rights to speak than their lawyers. An Instagram post as well as, I don't know if I can. And the judge said his communications from MDC. And Shapiro says to the court, he says the prosecution is motivated by racism. I don't know how that's an answer to the question about the MDC. Combs' lawyer Shapiro goes on to say, this is covered by the First Amendment. Messages they point to are not instructions to lie. There is a barrage of negative media coverage. He has a right to respond to that. The judge says, why not through counsel? And Shapiro said, we're happy to do that. And then Shapiro says, but we're lawyers. It's not really what we do. Some of these it's everything they've done every time they've been in court. Everything in court that they have talked about is part of their argument to the public as well. But Shapiro says, but we're lawyers. It's not really what we do. Some of these recordings show that he's telling people, just tell the truth, talk with my lawyer. The judge said, victim 3, you're saying that communications are fine. And Shapiro said, yes, the same with witness 1 and witness 2. The judge said, what about the communications that are missing? Shapiro responds, witness 1 reached out to Mr. Combs' counsel and asked us for a lawyer. We didn't do anything along those lines because it was an odd request. I don't know the factual answer. And the judge said, how did you not know? And then Garagos steps in and says, there was a message from Mr. Combs to witness 1. I like to give it to you under seal. AUSA Foster may know it does not give rise to the level of obstruction. I do not have the actual message. And then lawyer Garagos says, my client obeys me. For example, on victim 3, he stopped using ASAP and other phone lines. The messages with witness 1 were pre-arrest. He obeys us. He came to New York in the BOP. When I tell him not to do something, he doesn't. Shapiro said, I submit that the charges in the Jeffries Abercrombie case are worse than here. They allege an international sex trafficking business, and then they go on to describe actions from that and then cite to where it is said. Defense counsel Shapiro goes on to say, while in the Jeffries case, one defendant is 80, the other is 71. Mr. Combs is 55. I hate to say it, that's not that young. Ouch, counsel. Look, Shapiro is arguing for bail, not anybody's feelings, but I'm Sure, Diddy was sitting there being like, what? Come on now. 55 and 80 are different. The judge says the U.S. suggests he won't follow the conditions. Yeah, the U.S. said that very strongly. Shapiro goes on to say these conditions are more restrictive than in the prison. Okay. The judge then asked counsel, where is the home he'd be in? And counsel said, I don't want to give the address. It's on Star Island. There's a causeway, there's a dock, but there would be no boat. The judge said, that's not going to work. Where in New York? We already know the address is on Star Island. They've been in other filings, but that is in Florida, down in Miami. And then the judge said, no. What about New York? Which is interesting because this is the first time we've heard a judge actually indicate that maybe there's a consideration here in asking about what about New York instead of just saying no flat out, which is what we've seen the other judges do. Defense counsel says there's an apartment on the Upper East Side. We have one available, 3 bedrooms. The judge said, where are the 24/7 security going to be? We would like to speak to him or me. It's Patriot Security. They merged with Crisis 24. There'd be 2 security guards in the apartment and 1 downstairs, a total of 3. No access to phones or the internet except for calls with counsel arranged by the security personnel. This is more restrictive than in MDC. He goes on to say Combs would avoid all contact with anyone who may be a witness. I think he has a right to do that, but I want to make it easy for the court. We are going to investigate thoroughly before the May 5th trial. He has a right to assist. The judge then says the government is saying Combs would be paying these people. It comes down to trust. Combs's lawyer responds, it's a different relationship. These are professionals that are going to be in his life for 8 months. It's a high-profile case. Defense then says he's been in jail 66 days without a laptop. He only got one a few hours ago, which is unique here to have to wait 9 weeks to get a laptop into the MDC. The judge said the solution is for you to come to me. We can call these hearings and get things done, right? If it's taking you 9 weeks to get a laptop, bring it to the court's attention, is what the judge is saying there. Defense says, I've got a whole presentation ready about the tape, but if you've got enough, I can save everyone 15 minutes. Judge Subramanian said, I'll review it. Who is here from pretrial services? Pretrial services says, we maintain conditions are insufficient. So pretrial services said, do not release him. The conditions of release are not sufficient. The judge said, have there been other cases with private guards? Pretrial services says, not that I'm aware. I would like to mention the Fat Leonard case. I don't think that was out of New York, though. I forget which federal district that was. But he had paid private security and then it seems maybe paid them to look the other way because he slipped right out and was searched for months before he was found. The AUSA said, consider witness 1 a participant in multiple freak-offs. Defendant continued to contact witness 1 after counsel was retained. The Instagram post was planned for weeks using Contact Me ASAP and other inmates' codes. His family members said the lawyers said not to do it, and the defendant responds, I don't care, it's my birthday. The judge said, Ms. Shapiro said sharing codes is common, and the conduct was covered by the First Amendment. The U.S. attorney says the BOP handbook prohibits it, and defendant has used at least 8 inmates' codes. He's bought them. The judge goes on to say, they say Contact Me ASAP operates through a different telephone system. The AUSA said it's not permitted. In the Jeffries, 1 is detained. The judge said a foreign national. The AUSA said this is more similar to the case where detention was ordered. R. Kelly, Keith Raniere, and Larry Ray. The judge said, I suggest both parties put in letters by Monday at noon about what type of communications Combs may engage in. Monday at noon. I see people from the second row standing up. And then the attorney said we had to email for a week to get him a file folder. I don't know why we are there. Combs's lawyer said his adult children are willing to obey. He's not a lawless person. We spent hours at MDC. He was writing down what I said. He's not out of control. DOJ is responsible for the MDC. These calls from me all the time and I hang up. And then Combs's lawyer said he has access to cell phones in MDC, but not under our condition. He fights, he kicks, he makes phone calls. This can be addressed. Thank you. The judge says we're going to get a decision out prompt next week. Letters Monday adjourned. Period. This is the first time we've seen a court saying, tell me more about the conditions so I can make a decision. The other courts have said, I've heard what you said, enough denied. Let's take a look at those letters. In the defense letter filed on November 25th, the defense addresses quite a bit more law. Their intro to this is defendant Combs respectfully submits his letter in response to the court's request at the November 22nd hearing for further briefing on the contours of the, quote, types of communications that Mr. Combs is able to engage in, consistent with the court order and Rule 23.1 and the First and Sixth Amendments. For months and months, the government agents, plaintiffs' attorneys, and others with questionable motives have been flouting the airwaves with false and outrageous claims about Mr. Combs. This nonstop drumbeat of negative publicity has destroyed his reputation and will make it virtually impossible for him to receive a fair trial. Mr. Combs is not required to sit idly by and acquiesce to all of this. He has a right to a fair trial and a constitutional right to speak out on his own behalf. The government's argument that asking his children to post birthday wishes on Instagram and that he is not entitled to publicly express his opinion that this prosecution is racially motivated are quite simply an unconstitutional effort to silence him. They say Mr. Combs sought only to stop a wave of publicity he perceived as prejudicing potential jurors and injuring his reputation in the community, and they are citing another case that we have seen, the Gentile case from 1991. It goes on to say his communications directed at the public are protected under the First Amendment as free speech and cannot justify denying bail or indeed prevent him from engaging in constitutionally protected public relations efforts so long as they comport with the carefully tailored legal limits imposed by controlling authorities described below. And then they go through an evaluation of defendants' rights to speech, the First Amendment, and what the government's burdens are there, and that him posting or asking someone to post about his birthday is not intimidation. It's not witness intimidation. And that is what the defense is trying to argue, because that's been something that the prosecution has leaned into in their motions. The defense, though, still has to overcome the presumption that the defendant stays in custody based on the charges here. The prosecution also submitted a letter from November 25th that says the government respectfully submits this letter in further opposition of the defendant's renewed application for bail and following the November 22nd bail hearing in the above captioned matter. At the hearing, the court requested that the parties address whether the defendant's conduct constituted obstruction for the purposes of the Bail Reform Act. In addition, the court ordered the parties to address whether the defendant's conduct violated the court's October 25th, 2024 order and Local Criminal Rule 23.1, and what communications the defendant would properly be able to engage in on a prospective basis. They go on to say, for the reasons set forth below, the defendant's conduct, both past and present, constitutes obstruction, and his recent efforts to influence the jury pool are in violation of Local Criminal Rule 23.1 and in contempt of the very order incorporating that rule that this defendant demanded. The defendant's argument that any of his conduct is protected by the First Amendment are similarly baseless. They go on to say, moreover, as detailed in prior hearings and briefly addressed below, the defendant's history of obstructive conduct is part and parcel of his decades-long pattern of violence, which must be considered along with his obstructive conduct to fully assess his dangerousness under the Bail Reform Act. A holistic view of his obstructive and violent conduct that is still happening presently, makes clear that there is no way to rebut the applicable presumption of detention in this case. The bail package presented by the defendant does not come close to ensuring the safety of the community, including from the defendant's ongoing efforts to obstruct this case, nor does it adequately protect from risk of flight. For all these reasons, the defendant's renewed application of bail must be denied. And then the government goes on to talk about the defense's obstructive conduct as they see it, or conduct they characterize as obstructed, and go on to cite case law they argue supports their position. The government lines out the violation of the rules in the MDC and more, and goes on to conclude that there are not sufficient conditions of bail and that the bail request should be denied again. So the court said they will have a ruling out this week. Court is closed on Thursday, so will this ruling come down while this episode goes live? Maybe. Will it be Friday? Maybe. Either way, I'll update the description of this episode because I am going to be taking a little bit of time off because Tuesday there's a hearing in the Karen Reed case and I'll be covering that, but a little bit of time off over the holiday. And I hope you have a little downtime too to enjoy the time this year. I love a little bit of slow time. The family loves a little bit of slow time. Go see a movie. Yes, we're going to go see Wicked. Play some board games, play some Mario Party, and spend some slower days decorating for the holidays. but also not working, which in my case, and probably in yours, is a bit of a welcome respite. I love being here with you, law nerds. I love taking some time with family. I hope you're able to find some balance for yourself this week as well. I'm so glad that you're here. And hopefully this episode made prepping for cooking go a little bit smoother, because I know that's what you're up to while you're listening. So say it with me, because we're counting down to the final episodes of the Wednesday show. So may your Wi-Fi be strong. May your toilet paper be plentiful. May your family be well. And may the odds be ever in your favor. Thank you so much for being here. Thank you for being a law nerd. And if you want, let me know down below what your favorite sweet treat is this time of year, because my family has started fighting over pumpkin pie already. Absolutely have. The only reason they're not fighting over the Malin sticky buns is because they don't know that I've already put them in the freezer. So don't tell my kids that that's where they're hiding. For those of you that don't know what I'm talking about, sticky buns from New Jersey. For those of you who do know what I'm talking about, a delicious sweet treat. I will see you soon. Take care. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.